We're going to go ahead and get started as we have a number of questions that have been submitted to and just kind of get this thing underway. So first off, um, we'd really like to just thank you all so much for being with us this afternoon for our fourth town hall for the Paid Family Medical Leave Insurance Program. We really appreciate you taking time with us this afternoon to join us to offer some ideas, identify issues, make suggestions, or really raise any concerns that you may have relating to the program's development. With us today, we have Kelly Afani and Bree McGeehee with our Small Employers Work Group. We also have Rick Heineken with our Benefits Work Group, Caitlin Critton with our Equivalent Plans and Self-Employed Work Groups, Jason Boley with our Communications team, and then Lois Williams, Lily Hogue, and Leslie Chartier with our PFMLI Leadership team. Little rundown on how this afternoon's meeting is going to go ahead and go. We're going to start off with just a quick brief introduction of the PFMLI program by our policy manager, Lois Williams. And then Kelly will provide an update on where the program is when it comes to our small employer work group, our topic for today's town hall. When Kelly is done, we're going to go ahead and open up this town hall for questions or comments. Now, we did have a number of you that had sent us your questions before the town hall. We also had a number of small employer related questions that were asked at our previous town halls that were on contributions, equivalent plans, as well as benefits. So we're going to go ahead and address those small employer questions that have already been submitted or were submitted during those town halls first. And then we're going to go ahead and move on to those that were submitted during today's small employer work group. And you can actually submit those questions using the Q&A tab there at the bottom of your screen. Now, since today's session is intended to focus mostly on small employers, we may filter some of the questions related to other topics out, but we're going to get to as many of them today as we possibly can. I would encourage you, if you have not done so, to go and watch all of our previous town halls on contributions, equivalent plans, as well as benefits, as they may answer some of the questions that you have. All those town halls, were recorded and have been posted to the PFMLI website. So also just a quick reminder, we are taking questions at that Q&A tab there at the bottom. If you are listening by phone, which looks like we do have a couple of you with us today, please feel free to submit those at our website, our email, which is paidfamilyandmedicalleave@oregon.gov. You can submit questions anytime during today's meeting. Now, just as we have done with the prior 3 town halls, we are recording this town hall, and it'll be posted to the PFMLI webpage within a few days following today's event. Now, one thing that I really do want to emphasize is that because we are still developing PFMLI, there may be a lot of questions that you guys have today that we just simply do not have the answers to at this time. It could take us a little time to get those answers. We're really using this time to listen to you, gather those questions, comments, or concerns that will really help us build and implement a program that works for all Oregonians. So again, thank you so much for joining us and coming with us and listening to us today. And with that, I'm going to go ahead and turn this over to Lois Williams, who will provide just a brief explanation on the PFMLI program. Lois?
Thank you, Dean. And thank you, everyone, for joining us today. We're really excited to hear your input. Really, your questions are going to help us identify areas that we need to delve into further in order to provide guidance with better education and outreach over the next couple of years. So as Dean said, I'm going to provide a brief overview of the program. Most countries around the world do have a paid family leave program of some kind. The United States is only one of a few that don't offer this type of leave at the national level. Oregon, our program, the Paid Family and Medical Leave Insurance Program, was passed into law in 2019. Oregon is joining only 8 other states, plus Washington, D.C., in offering such a program. Of those other states that have paid family leave programs, 4 evolved from those states' existing disability insurance programs. Of the states with more recently enacted programs, Washington State and Washington, D.C.'s plans began paying benefits earlier this year. Massachusetts and Connecticut will each follow in the next couple of years, and then Oregon's program will start paying benefits beginning in January 2023. So when House Bill 2005 was passed back in 2019, seems like a long time ago now, but it wasn't that long ago, Certain timelines were included in the bill. The bill became effective in September of 2019, and it requires that the Employment Department provide reports back to the legislature on its implementation of the program at various stages throughout the next couple of years. Other timelines that were included were that administrative rules are to be adopted by September 2021. That's just next September, less than a year away. So we are well into that process now. That's why we're reaching out to getting input from you. Paid family medical leave contributions begin to be collected from employers and employees starting in January 2022, and then benefits will be available beginning in January 2023, 1 year later. The legislature funded the implementation of the program with a general fund loan, and that loan needs to be paid back in January of 2023. And then the program will be self-funded from the contributions into the fund from employers and employees from that point forward. So the program itself provides 3 types of leave. There's family leave, which provides paid time off to bond with a child during the first year after birth, adoption, or foster care placement, as well as to care for a family member with a serious health condition. The next type of leave is medical leave, which provides paid time off for the worker's own serious health condition. And then safe leave, which provides paid time off to respond to issues relating to domestic violence, harassment, stalking, or sexual assault. Now, here's quite a few more aspects of Oregon's program. Eligible employees will be able to take up to 12 weeks of paid leave. They may take 2 more weeks of paid leave for pregnancy, childbirth, or related conditions. Employees may take then an additional 4 weeks of unpaid leave for events that are also covered under Oregon's OFLA, Oregon Family Leave Act. The weekly benefit amount is going to be based on an eligible employee's prior earnings, like from a base year or an alternate base year. Employees who made average earnings up to 65% of the state's average weekly wage are going to receive full wage replacement during that time. Employees who made more than 65% of the state's average weekly wage would receive an additional amount, so there's a calculation involved, but benefits are capped. They're going to be capped at a maximum of 120% of the statewide average weekly wage. There's also a minimum benefit amount. It's equal to 5% of the statewide average weekly wage. So there is a threshold on the bottom as a minimum, and then a cap at the top as a maximum. Several job protection provisions are included in the program. For example, at the time that an employee returns from paid leave, they must be returned to an equivalent or similar position. Also, their seniority is not affected by taking leave. It's as if they had been working the whole time. They retain that seniority. Employers may not discriminate against an employee who inquires about paid family medical leave or who actually applies for and takes leave. Employers must continue to provide healthcare benefits while the employee is on paid leave. Now, both employers and employees will make contributions into the program, as I said, beginning in January of 2023. Employee wages up to $132,900 per year will be subject to contributions, and that maximum amount is indexed for inflation each year. The contribution rate itself is the same for all employers and employees, and it will be set once each year by the Employment Department, and it is capped at no more than 1% of wages. Of that maximum 1%, contributions are split between employees, who will pay 60% of the rate, and employers, who will pay 40% of the rate. Small employers that we're here today to focus on are those who have less than 25 employees. They do not have to pay the employer portion of the contributions, that 40% of 1%, but they may choose to do so. And so we'll talk about that a little bit more on the next slide. This particular piece of legislation provided a provision that employers can choose to have their own plan rather than participate in the state paid family medical leave plan. If they choose that route to have their own plan, their plan must provide benefits at least equivalent to that of the state plan or better. Employers will pay a fee to the department up to $250 so that the department can evaluate their plan and make sure that it meets that equivalency standard, that the benefits are at least equivalent to what workers would get under the state plan, and that the amount of leave that is provided, the duration, is equivalent or better than the state's plan. These employers and their employees don't pay contributions into the state plan, but instead they contribute to that employer's plan. And then benefits for those employees are paid out under the employer's equivalent plan. We are currently working on administrative rules for situations where workers have more than one job, with potentially 2 or more different types of coverage or plans. You could have an equivalent plan under one employer and then maybe the state plan under a different employer. Or where a worker has 2 jobs and each employer has their own equivalent plan. So we are calling those crossover situations, and we are trying to write administrative rules for how benefits and those procedures would work in those situations. Now, on the prior slide, I mentioned that small employers, again, those with less than 25 employees, can choose not to pay the employer's 40% share of the contributions. But if they do pay that portion, though, they can then apply for small employer assistance grants that can help offset the cost of hiring temporary replacement workers or other related costs, like overtime for other employees who have to or who choose to pick up additional shifts or additional hours or additional work while someone is out on leave. The grants are up to $3,000 and can be requested for up to 10 employee leave occurrences per year. House Bill 2005 included a requirement for the department to establish an advisory committee, and their role is to advise the director of the employment department on all things implementation, administration, and rulemaking for the new paid family medical leave program. They consist of 9 members. One is the paid family medical leave director, our division director, who chairs the committee. And then there are 4 individuals who represent employee interests and 4 individuals who represent employer interests, one of whom represents small employers. This group has been meeting monthly for just about a year now. They will serve a 2-year term. With the help of the advisory committee, we've established 5 additional work groups to bring in even more perspectives on developing the program. I'll just briefly run through what these 5 work groups are and what they're addressing in their meetings. First, the equivalent plans work group has begun discussing how that application process will work, along with identifying processes for how the department will help them renew their plan, will help them define when it needs to be withdrawn or terminated. They're also going to discuss what reporting processes these employers will be asked to do, and they will help develop rules for when disputes arise between employees and employers who have gone that route of the equivalent plan. The contributions work group is exploring who must make contributions, how to define wages, and how employers will report their information and submit their payments. They'll also take a look at areas involving the sale or transfer of a business and any interest and penalty issues, any recovery issues, such as if someone sends in the quarterly information that they're supposed to, but doesn't make a payment, how will we work with that employer to make sure that the contributions are remitted? The small employers work group is determining how and when to count employees, again, to determine if someone is a small employer, and developing the small employer assistance grant process. This work group is also clarifying the job protection provisions I previously discussed that affect all employees and employers regardless of size. And another work group is the self-employed independent contractors work group. The paid family medical leave legislation allows self-employed individuals, independent contractors, to elect coverage under the state's program. They must participate for at least 3 years, and their contributions are based on their taxable income rather than wages. And this work group is exploring those provisions. The last group I'll mention is the benefits work group that really is going to be looking at all of the issues related to eligibility and applying for benefits and the computation of benefits, the payment of benefits, even issues around intermittent leave. If someone doesn't need to take 12 weeks off all in a row, but instead needs to take a day off a week, how is that going to work? And this work group is taking a look at that. So I'm going to stop at this point, but before I turn this over to Kelly for a little bit more details about the small employers topic that we're here to talk about today, I just want to thank you again for participating. We are capturing all of your input here. So if we don't get to your question, don't be discouraged. This is why we're here. We want to hear your questions. But you will have additional opportunities to provide input as we begin posting early draft administrative rules on our website, hopefully within just a month or two. And we'll be sending out announcements inviting you when those are available. So please do comment and let us know what your thoughts are. And then again, there will be further input opportunities during the formal rulemaking processes throughout the next year. Look for spring and summer next year before we finalize those rules. So thank you very much, Dean. I'm happy to answer questions throughout the rest of the hour.
Thank you very much, Lois. So I just want to talk a little bit about the small employer work group and some of the topics that we are addressing. So as was mentioned, it's the small employers and job protections work group really, because we are looking also at job protections, which are relevant for all employers, not only small employers. The work group has been meeting since August, and we have members representing both the employee and employee perspective, including in particular small employers. So we've divided our work into three kind of main areas, which are on the screen, and we're focusing on the most important aspects in each of those in order to get the pieces in place in time for the program to launch. So for small employers, one of the first big areas we're working on is employee count, as Lois has mentioned. We've started by focusing on policy questions on employee counts to establish which employers qualify as small employers. So we're considering details on how those determinations are made, such as how employees are counted, how the average is calculated, who makes the determination, and what information will need to be reported, as well as how new employers will determine if they are considered small employers. We're also starting to look at policies for setting up assistance grants for small employers. So we're looking at what the eligibility requirements are, how the application process will work, and how the amount of each grant will be determined, as well as what the timing of those payments for the grants will be. So then on job protections, which as I mentioned are not limited to small employers, there are also some questions that we're looking at. Some of the questions that we're looking at include when those job protections apply. So specifically, some of the provisions in the bill only apply after the employee has been employed with their current employer for 90 days. So we're looking at how the 90 days are counted and how healthcare benefits are maintained while an employee is on leave, such as how the payment of premiums is handled. We are also clarifying the differences between job protections for small and large employers. And while both provide protective leave, there is slightly more flexibility for small employers when an employee returns from leave. We will also be looking at how job protections compare to the Oregon Family Leave Act, OFLA, which Lois mentioned, which provides unpaid protected leave, and working with our colleagues at the Bureau of Labor of Industries on unlawful employment practices in connection with those job protections. So as you can see, we have a lot of topics that we're looking into and a lot of work to do. And I'm really excited for this opportunity to hear your questions, your comments, any concerns about small employers and job protections. And I'm happy to answer the questions as best I can today. So thank you. And Dean, I know you have quite a few questions ready to go.
Kelly, we do. Lois, Kelly, thank you so much just for that brief introduction on Lois, what the PFMLI program, and then Kelly with regard to really what the small employer work group has been talking about and focusing on since it had been meeting. And so, yes, Kelly, we do have a number that had been submitted regarding kind of a number of those topics that you had mentioned. And so I'm going to go ahead and start it. And one of those was one of those three categories and that would be on, how do you count employees? And so the question was, we've received a number of questions about how the number of employees will be determined for employers. Could you explain how employees will be counted?
Thank you. So the law establishes that the number of employees employed by an employer will be determined on an annual basis based on the average number of employees in the preceding 12 months. So in that count, any replacement workers that have been hired to cover for an employee who took paid family and medical leave based leave will not be included in that count. So the method for determining the average number of employees still needs to be set in administrative rule. And we're discussing a number of the details with the work group on how to establish that method. Um, at this time, one of our recommendations we're working on is that it should be based on a head count rather than considering part-time or full-time employees differently. And we're considering using a monthly employee count to calculate the annual average, but there's still a lot that needs to be worked out. And this will be something that will be shared in draft rule for feedback along the way, because there's a lot of components into how that calculation is made.
Kelly, thank you. This question also for you kind of touched it on there, and it is a two-part question. The first part of that being, how will the department be determining the number of employees? And if employers are self-reporting, how will the department ensure that the number is accurate?
Thank you. So that's something that we're working on now. So we're considering whether the employment department or employers themselves will do the calculation on the average number of employees, and who will make that determination on whether an employer qualifies as a small employer. So our early thinking is that employers may make that determination, at least initially, but either way, we expect that the determinations will be based on employee counts that are reported by the employer. We haven't really looked further yet into how we would ensure compliance with that and ensure that those numbers are accurate. So that's something we'll be considering and sharing more information on. We do think the first source of information will be the employers themselves.
Kelly, thank you. This one also for you. Some employees work for large employers based out of other states that may not have 25 employees in Oregon. Will they still count as a small business?
Thank you. So that's also something that we're looking into. The law does not specify that the employee count should only include employees in Oregon. So our early thinking is that all employees might be included in the count, including those working outside of Oregon, but it's still something we're looking into and we'll have more details on later, and we welcome inputs.
Kelly, thank you. Another one. If a business is a small employer and not required to pay contributions, does that mean that the employees contribute 100% of the rate instead of 60%?
Thank you. That's such an important question. I'm glad to have the chance to clarify. No. So the maximum that an employee contributes is the 60% employee portion of the total rate, regardless of whether they work for a small employer or a large employer, or if their employer has an equivalent plan. Whatever that total rate is, employees will not be contributing more than 60%. They could contribute less. Employers may want to cover a portion of it, or there may be a lower rate for an equivalent plan. But no matter what, the employees should not be contributing more than that. But for small employers, they wouldn't have to contribute the 40%.
Kelly, thank you. And then this one, a little bit of a clarification, and that was they were wondering, can you clarify how much grant assistance is available to small employers and what is required to receive the grants?
So in order to apply for grants, an employer would need to have fewer than 25 employees and have chosen to pay their employer share of the contributions. And obviously, there'll be a lot more details on that we're still working out now, but those are kind of the core requirements. Employers can apply for assistance grants up to 10 times per year, once for each employee that's taking leave under this program. For employers that choose to hire a temporary worker to replace their employee while they take leave, they can apply for up to $3,000 towards the cost of hiring a replacement worker. And if an employer decides not to hire a temporary worker, but may have additional costs such as overtime or training, they can apply for a grant of up to $1,000 to cover those costs. And employers will need to provide written documentation that they've hired a temporary worker or that they had these additional wage-related costs due to an employee taking leave.
Kelly, also kind of a clarification, and that would be, can you explain the differences in job protections for small and large employers?
Thank you. So all employees, regardless of whether they work for a large or a small employer, are entitled to be restored to their original position as long as that position still exists when they return from leave, regardless of whether a replacement worker filled the position while they were on leave. However, if the position no longer exists, there are some differences between large and small employers. For large employers, if the position no longer exists, the employee is entitled to be restored to any available equivalent position with equivalent employment benefits, pay, and other terms and conditions of employment. But for small employers, if the position no longer exists, the employee may restore the employee to a different position with similar job duties and the same employment benefits and pay. Now, the nuances of those differences are still something that we're looking into, but there is a slight difference between large and small employers. In addition, all employers are required to maintain healthcare benefits for the duration of their employees' leave and maintain any accrued employment benefits, including seniority and pension rights.
Kelly, this one also for you, and also related to job protections. And are the job protections for the paid family and medical leave insurance the same as for the Oregon Family Leave Act?
Thank you. And this has come up a few times, and it's there are a lot of similarities on the job protections for PFMLI and OFLA, but there are also some differences. So employers with 25 or more employees are covered by OFLA, may be covered by OFLA, and are required to provide employees with unpaid protected leave. So the job protections for OFLA seem to be similar to those established for PFMLI for large employers, because they're based on employees being returned to any equivalent position. So there's a similar terminology. But I think it's a really important difference to point out is the fact that PFMLI also covers employers with fewer than 25 employees. So job protections are available for employees who work at small employers with some slight difference in terminology, as I mentioned before, but that's different from OFLA, which would only apply to those employers with 25 or more employees.
Kelly, thank you. And then this one also for you. Who is responsible for paying healthcare premiums during leave?
Thank you. So how it's written in the law is that employers are required to maintain an employee's healthcare benefits for the duration of the employee's leave, as if the employee had continued employment during that period. So we believe that also applies to the premiums, but we're still looking into what exactly that means for how payments are handled and how that works while an employee's on leave. So we'll have more information on that in the future.
Thank you, Kelly. And this one also kind of a two-part question, and it being, will this be a requirement for all Oregon employers? If we are not required to offer paid sick leave due to the number of employees we have, will we be required to participate in PFMLI?
Thank you. So yes, all employers are covered by PFMLI regardless of their size. The only employers exempt are the federal government and tribal governments. The tribal governments in Oregon can actually elect to participate in the program. However, employers with, as we've mentioned, employers with fewer than 25 employees are not required to pay the employer portion of contributions for the program. But they still must withhold and report their employees' contributions, and their employees have the right to take the leave. If those small employers choose to pay the employer portion, then they can apply for grants of up to $3,000 per employee who takes leave to help cover those costs while their employee takes leave.
All right, thank you, Kelly.
And Kelly, you're cutting out a little, or it's sounding like you're a computer voice. You might want to move away other tech from nearby, like if you have a phone or things. Let's see if that helps. Thanks.
I was making sure. I thank you, Layla. Wanted to make sure that wasn't just me. And so, Kelly, I'm probably going to have you answer that again, just because you did kind of sound kind of muffled on that. So, and the question was, will this be a requirement for all Oregon employers if we are not required to offer paid sick leave due to the number of employees we have? Will we be required to participate in PFMLI?
I'm sounding a little clear. I can't obviously tell, but no.
It sounds like you are. I might have Lois. Would you mind taking this one if that's all right until we can kind of figure out what's going on with Kelly's audio on that? The world we live in with Zoom, I guess, right now. So if you wouldn't mind, I'm going to go ahead and toss that over to you until we can kind of see what's going on with Kelly's audio. And so Lois, I'll go ahead and kind of repeat the question just for you. And that is, will this be a requirement for all Oregon employers if we are not required to offer paid sick leave due to the number of employees we have? Will we be required to participate in PFMLI?
I do have Kelly's notes here because she had gotten this question in advance. So all employees are covered by paid family medical leave, regardless of their size. There's only a few employers who are exempt from paid family medical leave. That's the federal government and tribal governments. But tribal governments in Oregon, they can elect to participate in the program if they choose. Employers with fewer than 25 employees are not required to pay that employer portion of contributions for the program, but they must still withhold and report their employees' contributions. So if those small employers choose to pay the employer portion, they can then apply for grants of up to the $3,000 that Kelly explained per employee who takes leave to help cover the cost. So hopefully that explains that, yes, this applies broadly in Oregon.
All right, Lois, and this actually, these next two are directed to you. And that one being is, again, Lois, is when will the contribution rate be finalized?
Well, we don't have an answer for that yet, but we know that contributions are to start on January 1, 2022. And that means we aim to publish the initial rate well in advance of that date so that employers and employees can be prepared as of January 1. But we don't know exactly how far back that needs to be. The initial rate is going to be set so that a year later, by January 1, 2023, there's funding available to not only repay the general fund for implementation costs, but to cover benefit payments that start at that date and for up to 6 months. We have an economist on staff who's currently analyzing all of the available data to make projections in order to set the initial rate. So it will be sometime during next year, but at this point, we don't have a timeline. We just know that we need to get the word out to all employers well before that January 1, 2022 date.
Lois, this one also for you. Thank you for that. This one also directed for you. And they were wondering, is the quarterly report for PFMLI different than the one already required for other quarterly payroll taxes?
Well, again, I have to say we don't know yet, but we are in the process of defining business requirements for paid family medical leave technology systems, and we're exploring options for working with the Employment Department's modernization program, which is currently updating systems for the unemployment insurance program. Employment Department and DAS, the Department of Administrative Services, are currently in a vendor procurement process. They're selecting a vendor to modernize the UI tax and benefit systems. And hopefully they will enter into a contract negotiation stage very soon. Once that vendor is selected, we also hope and need to explore with them whether the same solution that was proposed for the UI tax reporting and collections will also meet our needs for reporting and collecting paid family medical leave contributions. We know that the vendors involved in that process both have done that type of work before. So as soon as we have a notice of intent to award issued and we can talk to the vendor, then we can move forward with that decision making. And we're going to share updates with all of our stakeholders and oversight entities on how those discussions are going and when those decisions are made.
Lois, thank you so much. And so we have about 3 more that were submitted ahead of time. And so these ones are for Kelly. We're going to check and see if her audio is good to go. Looks like she did change rooms on us. And so Kelly, this one back for you. And that being, are employee PFMLI contributions deducted from wages on a pre or post tax basis?
Thank you. I'm hoping you can hear me.
Yeah, sounds like your audio is still a little choppy on that one. Lois, I know that you have Kelly's notes on this. Would you mind taking that one? So again,
Sure.
The question being, are employee PFMLI contributions deducted from wages on a pre or post tax basis?
That is a great question. We are just starting to look at. Kelly's work group is literally doing research on this right now. So we are looking into it. Our early thinking is that contributions as a starting point are based on gross wages, but we're taking a look at how pre-tax deductions such as 401k contributions or medical expenses that come out for flexible spending accounts. Those are the types of pre and post-tax deductions that people have every day coming out of their gross wages. And so we're going to be taking a look at each one of those and seeing where it falls in relation to paid family medical leave contributions. We don't have an answer yet, but we're working on it right now.
Lois, I'm going to do this one just because I saw that Kelly had turned off her camera, says she works to kind of fix up those audio issues. And this person was wondering, can you help us prepare for potential administrative burdens?
Sure. We know there's a lot of details that we're trying to figure out on the department's administration, but also we know this is going to be a change for so many employers involved. We do know that employers are going to be responsible for deducting contributions from employees' paychecks and then for filing wage reports and remitting the employee and the employer contributions quarterly. We don't know what that looks like yet, but yes, we know that responsibility exists. Employers will also have to keep payroll and employment records, and employers will be required to provide information about the program to their employees, and we will be providing a sample notice for employers to use for that. The exact processes and procedures still need to be determined. We do plan to put out employer guides, have information available online, such as frequently asked questions or guidelines to help individuals, not only employers, step through the steps that they need to do in order to comply, but also to help workers who want to come forward and claim benefits. We want to make it as easy as possible. So while the procedures and the processes still need to be determined, because we don't even have a system yet, but we're building those requirements, we do welcome inputs along the way, and we'll definitely share when we know more. As I indicated, we do plan to provide detailed guidance to different audiences, such as employers, employees, third-party administrators, such as a payroll service company. We want to have all of that in place well before contributions start in January 2022.
Hi, Lois, and it looks like Kelly's still kind of trying to figure that out. And so this one is the last question that I have that had been submitted beforehand, and then I'll toss it over to Lily. And that question is, what notices will employers need to give their employees for PFMLI?
That's a great question. What I just mentioned is that employers are required to provide written notice to each employee on their rights and duties under the Paid Family Medical Leave Program. So we're going to be working to develop more specific guidelines on that notice, and we'll provide employers with a model notice that they can use that meets the program's requirements. Employers are required to provide this notice in the language that the employer typically uses to communicate with their employee.
All right, Lois, thank you so much for stepping in there for Kelly as we kind of work through those audio issues and Zoom. She's back now, and so I'm going to go ahead and hand this over to Lily, who's been really kind of looking at all of the questions that were submitted during today's meeting as she's been facilitating that. So Lily. Hi,
good afternoon. This is like the equivalent of, I don't know, spilling a cup of coffee on you before you start presenting or something, but online. We have a lot of great questions. I'm going to start by asking Kelly one, and if it doesn't work out, it's just going to go straight to Lois, all right? So this is actually a great question. Somebody asked, so if the employee only puts in 60% at a small employer, and the employer doesn't put in the 40%, who does put the 40% in, or how does the fund work?
Sound.
Yeah, still.
We're going to go straight to Lois.
So thanks, Lily. I think, and I think I want other team members to participate today too. I believe the question is if the 40% isn't getting paid, what happens to it? And the answer is small employers have that option. They will still remit over the 60% from their employees, but they won't pay the 40%. They won't be eligible for those small business assistance grants, but all of the incoming contributions go into one large fund, the Paid Family Medical Leave Insurance Fund, housed at the Treasury. And all benefits and administrative costs of running the program come out of that fund. It's one big pool that all of the dollars go into. And that's where our economist comes into making projections. We always want to have at least 6 months of solvency in that fund. So she will be looking forward to what is the amount of benefit claims that are coming in, what are the trends in the contributions, and so that on an annual basis we can adjust that rate, again right now not to exceed 1%, over time to keep that fund solvent. So does that address the question that you asked?
That's great. And Lois, how did the employment department arrive at the definition of small business being 25 employees? Was that statute? Is it rule? Is it a decision we made?
That's in the statute. The statute specifically says a small employer is one with fewer than 25 employees.
So one of the questions folks had, and Lois, or actually, no, this one can go to Rick. If an employee pays a portion of the health insurance while they're out on leave, how will you account for that to be paid while they're off work? How would we do that?
Say the question one more time, please.
This says if an employee pays a portion of the health insurance, which we know they need to, right? Let's say we know that health insurance needs to be maintained while somebody is out on leave, but let's say they normally pay a portion. So how will the employer get that money, or how will that work while they're on the leave?
Most of those questions would be set up ahead of time with the employer's health insurance coverage. If an individual is currently on their health program, the job protections that are in our system would protect them from their employer dropping them from their health coverage. Most of those systems should be already set up ahead of time as far as the payments going in there, but I don't know about. I know we've started a lot of our conversations with the Bureau of Labor and Industries about how those job protections will work and how those kinds of things will happen. I don't know if we're quite ready to answer that question at this time, but it is one of the questions that we are going to be looking into.
Thanks. And Lois, I have a few for you. So somebody asked, this will also apply to immigrant-owned businesses, so who started their businesses with an ITIN or ITIN, tax ID number, as opposed to a social security number. How will that work?
That's a great question. As I said earlier, self-employed individuals will make their contributions based off their taxable income. So they will have to provide us some kind of a tax identification number. And then if they apply for benefits, we will pay out those benefits based on their claim. But if they don't have a social security number, that there's nothing in the law that prohibits them. We are trying to prohibits them from participating. We haven't figured out exactly how our system is going to handle that yet, but it's a valid question. But certainly a self-employed individual can elect to be a part of the program.
And Lois, do the 4 weeks of unpaid leave apply to employers who are not subject to OFLA due to size?
Oh, that's a good question. I think so, but I don't know. I don't want to speak out of turn. Remember that the benefits are 12 weeks of paid family medical leave plus an additional 2 weeks for pregnancy, childbirth-related issues, and then up to 4 weeks of additional unpaid leave for OFLA-covered conditions. So if an employer is not covered by OFLA, I would have to take a look at that before I gave you a hard answer.
Thank you. A couple more. So if an employer miscounts employees, how much time will they have to remedy the situation? How much time do they reporting, and how often are they reporting and remitting payments? How will that work?
Well, we know that employers are going to be asked to report and remit quarterly. If they make a mistake on their employee count, of course, they can correct that with us by filing amended information. But right now, as we consider employee counts, I believe that we're thinking about making a determination once per year. And so if we have to adjust once per year, that's fine, but it's not as if it would change throughout the following 4 quarters. It would be a determination made, and then they would stay with that designation of either a small employer or not throughout the next year.
Got it. And Kelly, I'm going to try to kick this one to you. So we have a question. That's a great question here. So the $3,000 assistant grant, is that for the whole 12 weeks? Is it per week, per month? How will you assess how much people get? Do they just get $3,000? You're on mute. Nope. Lois.
You're going to ask me all the hard questions.
Yeah.
I do know that the statute goes through a little bit of a computation that the $3,000 is a maximum. So it's up to $3,000. If an employer only spends $1,000 to replace a worker, then that's what the amount of the grant would be capped at. What they spent up to $3,000. I do know there's a small situation, and I apologize, I haven't looked at this in a little while. The exact wording says, if you apply for the $1,000 grant, which is because you have to pay other people overtime, or you have to provide some extra training, and then later determine that you have to hire a replacement worker, you can apply for an additional grant. And I'm going to say up to the $3,000 mark, but you can apply for further grant and still have it count as the one of your 10 for the year. So depending on which type of grant you apply for first, the $3,000, that's up to $3,000. The $1,000 you can later apply, it's up to $1,000 and then up to $3,000. And I will quickly look at Kelly to see if she's giving me a thumbs up or not.
Can you hear me?
Yes.
Yep.
Sounds great.
That's exactly right, Lois. So if you make the initial decision that you don't need to hire a replacement worker, then you can get up to $1,000 towards the cost. If the employee ends up extending their leave, and then you decide that a replacement worker is needed, you have the option to apply for the difference. So had you received the full $1,000, you can now receive up to an additional $2,000.
Thank you. And Kelly, that's just for small employers who choose to opt into paying their portion of the family leave benefit.
Exactly. And that's per employee, that's the maximum. So they can have up to 10 different employees on leave and receive grants for them per year.
Okay. And Kelly, is the annual employee count going to be based on a calendar year or a rolling year of quarterly reports?
That's something we're still looking at. The law is phrased that it's an annual determination. So I think we're looking at it probably being a once per year thing that's determined. But what the period of time that's looked back on and what the period of time that it's in effect for are things that we're still discussing with the work group and kind of formulating our recommendations.
Thank you. And so can you describe if an employee leaves their position and they come back and can you kind of describe the difference between equivalent position and similar position again?
Yeah, I can try. So for a large employer, it's phrased that if their job is no longer available, then they would be returned to an equivalent position. For a small employer, it says it can be a different position with, I'm sorry, I don't have it written in front of me, with the same kind of duties and the same pay. What exactly the difference is between an equivalent position and a different position with the same kind of terms of employment is something we're still looking at and trying to understand more ourselves. So I don't have a specific answer on how exactly those are different, but there's a slight difference in how it's phrased.
Okay, and how long does a small employer have to contribute to the program to be eligible for those grants?
You know, that's one of the things we're focused on right now. It's not specified in the law. It just says that they need to contribute when they're not required to do so. But what period of time they need to contribute or what period of time is looked at when deciding if they're eligible for grants, those are things that we're working on now and we'll definitely have more guidance on in the future.
Thank you. And so how will we be determining employees within the state overall? We've got a couple more questions about that. So how will you define whether you have 25 employees or not?
Mm-hmm. Well, there's still a lot of elements of that we're still figuring out. So as I mentioned at the beginning, we're thinking that it's going to be a head count. So based on the number of employees, we're considering whether it's a once per month count that's been averaged over 12 months or whether a different unit of time might be used. there's still a lot of those details that need to be figured out, but we know that it's a look-back period. So you'll be looking at what the previous 12 months employee count was. And we know that it'll be an average. So it's not a total of number of employees in the entire year. It's going to be an average of a monthly or some other period of time over those 12 months. But as far as the very specific details about how that count is calculated, we're working on that, and we're going to try and have really good guidance for everyone. And we look forward to getting inputs and suggestions from everyone as well.
Thank you. And I'm going to take a couple more questions before we wrap up today. But that is, of course, as you can tell by many of our answers so far, we have just started this process. And in fact, someone was asking, will there be another town hall focusing on self-employed or independent contractors? And I'm wondering if anyone, Caitlin, knows when and where and what that will be.
You'll have another one just for self-employed and independent contractors. And it is on December 8th. And I need to pull up my calendar because I don't want to say the wrong time. But I believe it's from 6:30 to, or 6 to, sorry.
6:30 to 7:30.
Yes, that would be right. Thank you.
I can see your son just walked up behind you, and he looks like a little jump in the dark.
Sorry about that.
And we actually have another question that I'm going to answer because it's part of my role. Somebody asked, will you have other outreach to small employers? And will you have it at different times of day so that different types of employers can attend? Because we know that people have schedules, many people are working right now. We have had some at night. We've had some town halls during the day. Again, like I just said, this is actually just the beginning of that conversation. So I'm responsible as one of the leadership team members for a lot of our outreach, planning and work. And with my team, we will absolutely be making sure that we're doing outreach with small employers over the coming year during the rules process. But of course, throughout the next years, this program hopefully will be around for many hundreds of years even. And so it will continuously need the input and feedback, and we want of small employers, and we want to be able to support you all as we ramp up and then actually implement the program. And I actually think we've answered everyone's questions for today. Yeah.
Lily, we've had a couple that came in just quick. I think they were sent in over the email. We did have a couple that were sent in over the email.
Great, go
and
for it.
So we had 2 of those, and so I'm going to go ahead and address those. And most of them are pretty kind of the same theme, if you will. And so I'm going to go ahead and this one would be either for Kelly or Lois, and it kind of is with regard to with Washington's currently in, and then ours kind of starting up in 2023 with benefits. And so this person was wondering, do the employees need to reside in Oregon to be eligible, or do they need only earn that 1,000 in the state of Oregon to be eligible?
I can answer that. So the PFMLI program, hopefully the PFMLI program for Oregon is based on where your work is performed. So if you are earning wages in Oregon and paying contributions to the Oregon program, you're eligible even if you live in Washington.
All right, thank you. And then kind of on that same line, Kelly, and that would be if there is an event where Oregon and Washington are paying out paid family and medical leave insurance, do the benefits coordinate?
Thank you. And Lois may have some additional clarification on this one. At this point, the programs are operated separately. They are, if you qualify in Oregon based on your wages in Oregon, you can be paid out benefits in Oregon. There's no interagency arrangement, so any determinations for Washington would be a separate consideration.
And I'll just add, thank you, Kelly. I'll just add that we are talking to the state of Washington because we want to understand their program as much as possible. As you just answered in the last question, it really isn't a matter of residency, it's a matter of where the work is performed. So we know, for example, that there are people living in Oregon right now who travel into Washington to perform their job there, and they are covered possibly under the Washington program. Each program has a different threshold for being covered, whether it's the length of time someone has to work or the amount of money that they have to have made during a base year. So the programs, of course, are different. They're both administered differently by each of the states. But that doesn't mean that we don't want to talk with Washington. We know that there are also employers who have employees in both jurisdictions. We also know that there are employers or employees who go back and forth all the time. That's part of their regular routine, is to work within both states. So we have open conversations going on with the state of Washington to just make sure that we understand what we can do to provide good guidance to people in those situations.
And then Lois, the last question that was kind of pertaining to a little bit piggybacking off of that would be, what if an employee works for a company in Washington and does jobs in Oregon that total more than $1,000 in earnings, but are also meeting the criteria to qualify for PFMLI in Washington? Is the employer going to need to pay into both the Oregon and Washington programs?
That's a great question. Right now, we're taking a look at Oregon's place of performance wording in our statute, because it really is designed for Oregon being your primary workplace. Any work outside of Oregon should only be incidental to your primary work in Oregon. So just recently, one of the work groups had a conversation about, well, just what is incidental? If it's temporary or if it's just an occasional trip out of the state, your primary work is still in Oregon and you would be covered under Oregon's program. On the other hand, there are people who maybe do a much more significant amount of work outside the state of Oregon. In those situations, we want to make sure that we're providing clear guidance that it's about, is your primary workplace in Oregon? What does that look like? What are examples? And that conversation is going on right now.
I thank you, Lois. That was the ones that we've gotten submitted into the email. Lily, have there been any more that have been submitted in the Q&A tab there at the bottom? All right. Well, looks like we're right on time, actually, 2:57. And so, I think we're going to go ahead and wrap it up, and just wanted to thank you all so much. For myself, as well as everyone with the Paid Family Medical Leave Insurance Program, really can't thank you enough for, coming and submitting your questions to us this afternoon. We really appreciate all of the feedback that, that we've received today. Now, today, a small employers meeting, again, was recorded. So if you'd like to go back and watch or share with a friend or another employer, please feel free to do so. It's going to be posted on the PFMLI webpage under the Town Hall tab by the end of the week. Also want to thank you for the kind of the audio problem that we have, that we had with Kelly there. Thank you so much for sticking with us as we work to get that figured out. So thank you again. And so this was the fourth town hall. The next one is scheduled on December 8th at 6:30. That's going to be an emphasis on the self-employed and independent contractor. These 5 town halls are just the start. As Lily had mentioned, we do plan to continue to hold these really over the course of the next year. So you'll have, plenty of additional opportunities to provide input as we begin posting draft administrative rules on our website. And then again, as Lois mentioned, during the formal rulemaking process throughout the next year. Finally, we are always taking feedback. So if you think of something else, please don't hesitate to reach out. You can submit those at paidfamilyandmedicalleave@oregon.gov. Also, don't forget to sign up for the PFMLI updates. So with that, thank you all so much for joining us this afternoon, and we really appreciate all of your time. And then with that, it concludes today's meeting. Thank you.